My name is David Gallo. I'm the director of the AIFC Academy of Law. And I'd like to welcome all of our guests today who have joined us for another exciting webinar. We're broadcasting today from Nur Sultan, Kazakhstan. And first and foremost, we hope you all are well. We hope you're staying safe. And we're very pleased that you're continuing to participate in these legal education opportunities during this pandemic. And we also are very pleased that you continue to move your law firms and your businesses forward during these difficult times. Today we have really a great event. It's a great way to close out Friday afternoon and head into the weekend. This is on a very relevant and practical topic at the AIFC relating to the transfer of incorporation under AIFC laws. So we're really going to be talking today about the practical aspects of redomiciliation to the AIFC. So this is basically the transfer of domiciles of existing businesses in other jurisdictions over to the AIFC jurisdiction. Today's speaker, who I will introduce momentarily, will cover several topics, including legal aspects of incorporation from other jurisdictions to the AIFC, financial regulations and special requirements of redomiciliation to the AIFC, and some practical case examples of what that transfer might look like and what are some of the practical issues to be encountered and overcome in this process. Our speaker today is Mr. Kuanysh Shekerbekov. He's a senior associate at Kinstellar law firm in Almaty. He has been practicing law since 2005, and he specializes in corporate law, M&A, banking, tax, and financial and cross-border transactions, with specialties in oil and gas, mining, energy, and telecommunications. He also advises clients on AIFC legislation. Kuanysh advises issuers, financial institutions, and other market participants on a variety of matters, including on one matter, which was the first IPO listing at the AIFC. So with that, it's my distinct privilege and honor to turn the floor over to Kuanysh.
Thank you, David. Hi all, my name is Kuanysh Shekerbekov. It's a great pleasure for me to be here with you and to have this opportunity to discuss with you our experience of working with AIFC, and particularly on the project of transfer of incorporation for one of our clients. Yes, as David said, we are Kinstellar, we're an international law firm. We work on various topics related to AIFC, as well as on many projects on capital markets at Astana International Exchange. But today, particularly, I'm happy to talk about transfer of incorporation under AIFC laws. It's one of the ways to set up business at AIFC. And before we started working for our client, we noticed that yes, AIFC platform provides for such mechanism, for such option to basically move existing company from foreign jurisdiction to AIFC, but we encountered certain practical issues of how it would look like in practice and how it would look like, and especially given that for Kazakhstan this concept is very new. We don't have such concept, and in this respect it was also kind of challenge for us as a law firm, and we noted that AIFC framework has a good, strong and solid legal platform to use this option as alternative to create business at AIFC. So yeah, we as I said, we advise a lot for our clients on AIFC, and our client, Kazakhstan Energy Reinsurance Company, we advised them on redomiciliation of Kirk from their initial jurisdiction, which was in Bermuda, into AIFC jurisdiction. So in this respect, we were the first company. Kirk was the first company which was registered at AIFC as existing foreign company by way of this solution, by way of transfer. So now I can tell that this option works in practice. It has been tested by us. So I think it took us 2-3 months to transfer long established business in foreign jurisdiction into AIFC. And in this sense, I think this option could be considered by foreign investors for the companies which are already exist in foreign jurisdiction. This option could be something which foreign investors, foreign existing companies could look up. So my today's discussion would be based both on statutory provisions. I will try to summarize in brief the statutory platform, how to make this in practice, and also certain practical points, practical hurdles that we had when we transferred care to AIFC. So to start with, the statutory provisions, yes, as I said, AIFC framework, AIFC's regime provides transparent, in my view, and very flexible and simplified procedure to transfer foreign company into AIFC. And foreign company which wishes to apply for this option, currently there are three types of corporate vehicles that can be transferred from foreign jurisdiction into AIFC. Those are company established either as private or public company, limited partnerships, and limited liability partnerships. So those three main corporate forms that can be transferred freely from foreign jurisdiction to AIFC. And here I would like to note that those three types of companies, they commonly accepted forms, corporate forms in other jurisdictions. So in this sense, it's in practice, it's not a problem to transfer existing, let's say, private company to AIFC. And here also I would like to note that this particular option doesn't affect the existing rights, existing assets, liabilities of company when it moved to AIFC. So all existing scope of rights and liabilities of the company will continue to work and continue to exist in AIFC. And in this sense, when the company is transferred from foreign jurisdiction to AIFC, it's not a new company per se. It's still same company, just only that it has changed its jurisdiction. So those are two main features, I would say, of this particular option. Sorry, yeah. Yep. The next point, why transfer of incorporation may be more attractive for businesses. Obviously, there are a number of reasons for that. One of them is that AIFC platform can be seen as convenient mechanism, because convenient mechanism for existing companies which have large assets, which have existed for many years, and obviously to liquidate existing company would take more time. So in order not to liquidate such existing company, transferring it to AIFC could be a suitable option. So in this sense, that's, I think, one of the main maybe reasons of using this way of opening business in AIFC. Commercial reasons, obviously, as you may know, AIFC provides for a number of tax and legal privileges, and since it is transparent, also legislation, jurisdiction, from commercial point of view, opening business in AIFC by way of transfer of existing business could be also more attractive. Then also on the slides here, you can see the third bullet point is similarity of regulatory regime framework. Also, just a brief background, you may know AIFC is a special and independent jurisdiction within Kazakhstan, which has its own legal platform. It has its own dispute resolution forum, and it's all based on, generally based on principles of English law. And as a result, it provides wider and broader instruments and options for investors. So from investors' point of view, this is something which very familiar for foreign investors. And in this sense, moving to AIFC would be familiar for them. It would be familiar territory, let's say. So it won't be an unknown zone for them. Apologies. And also one of the reasons when transfer may be more appropriate when continued incorporation in home jurisdiction is inappropriate. Obvious examples would be when companies existing in tax haven jurisdictions in offshore zones, which in many cases wouldn't be accepted for international banks. This may work when a company wishes to attract international funding from well-known international bank, and being in such tax haven zones may not be well viewed by banks. So transferring to more transparent zone would be more sensible and more reasonable. So these are four main reasons when transfer may be more appropriate. Of course, there may be other reasons to transfer existing business to AIFC. Moving to the next slide. When it comes to process itself, obviously I can't describe the whole process now, but I try to summarize. The process, and based on our practice in general, there are 5 main steps which a foreign company should take into account when using this option. So the first one is permitted jurisdiction point. It means that before even considering this option, foreign companies should analyze its jurisdiction, whether it generally provides such opportunity to move its existing domicile to another country. So if it allows, then a company should take corporate resolution approving such proposed transfer. And here it's important to note that, again, it depends on jurisdiction, but sometimes passing a corporate resolution may involve certain corporate formalities which the company must comply with, such as prior notification of its shareholders, time required for convening such meetings. So this is something which may have impact on general timelines. So this is And this also can be considered as main trigger. And this is also the document which will be required later on for AIFC purposes. And once the approval is obtained on on corporate level, the next big and main step would be obtaining all relevant consents and approvals in the home jurisdiction. This is also something which would be very relevant for AIFC purposes. In practice, it would include tax authorities, it would include various regulators, such as financial regulator, central bank, if a foreign company is subject to certain licensing requirements in its home jurisdiction. So those statutory clearances must be also launched, and must be all relevant consents and approvals must be obtained. Once this is done, company can apply for transfer of incorporation. At AIFC level, the documents must be applied to AIFC's register of companies. There is, of course, certain procedure in place. There is a package which must be prepared for such application, and depending on the type of the company, whether it is private company or public company, or if it is limited liability partnership, there is certain list of documents. Just overall, in summary, I can say that the process is not complex, it's not complicated. It's, I would say, feasible in practice. So application stage, once the application stage is done, once the documents are applied, are submitted, AIFC's register of companies launches its review process, and again, approval at application stage, depending on the company and depending on its existing activities. In certain cases, the register of companies at AIFC will need to obtain a separate approval from AFSA, which is a financial regulator in AIFC. This is the case when foreign company exists as fund and when it provides certain financial services. So in this case, the AIFC's register of companies may need to obtain separate approval from pre-approval from AFSA, but this is something which register deals with. And when the application process is completed, and when the company, if the company meets all requirements, then certificate of continuation will be issued for foreign company, and this certificate will be treated as a certificate of incorporation or registration at AIFC. And the final stage, foreign company will need to submit the certificate issued by AIFC to its initial jurisdiction, so that it is excluded from the register of companies in its initial jurisdiction. So those 5 main steps, and of course, in application stage, there is, as I said, statutory procedure. There is a list of documents, and this process can be launched when the company starts thinking about this option. And even at the stage of passing corporate approval, the company can already start working with AFSA in advance, and to establish contact with AIFC, and to start this process as early as possible. The next point, and obviously I will be happy to answer your questions about each of these steps at the end of my presentation, especially if you have any specific or technical questions on application process, I'll be happy to answer later. The next slide, which is our experience from KERK precedent, which I mentioned at the beginning. So before transferring the business to AIFC, there are a number of issues which foreign companies should consider and should take into account. And I would divide those issues into three main issues, three group of issues: preliminary issues, intermediate issues, and post-transfer issues. At preliminary issues, a foreign company, first of all, should see and should analyze the current scope of its business, its current financial arrangements, and it may be the case that current loans or facilities provide for certain covenants restricting such transfer to another jurisdiction. So if this is the case, then the company will need to prepare a list of such creditors, banks, contractors who must provide their consent for this proposed transfer. So this is sort of contractual due diligence which foreign companies should conduct internally. Then, of course, foreign company, before moving to another jurisdiction, obviously it should analyze and compare its current jurisdiction with AIFC's jurisdiction, whether it suits its business and whether it will be convenient and suitable for its business. But again, as I said at the beginning, AIFC provides similar instruments, options for international investments, for international investors, which are commonly accepted in other jurisdictions. So in this sense, I can say that AIFC platform provides flexibility, and it's also transparent as jurisdiction. And another preliminary issue, which is also very important before transferring to AIFC, is requirement about obtaining any licenses at AIFC. So foreign companies should see whether its current business, which it conducts in its home jurisdiction, whether it triggers any licensing requirements at AIFC. So this is mostly relevant for financial institutions, banks, insurance, reinsurance companies, brokerage companies, funds. So if foreign company carry out those services or similar services, then yeah, most likely to move this activity to AIFC, it would need to obtain separate license, new license at AIFC. So this is the one of the main factors which needs to be taken into account when preparing timeline for transfer, because obtaining license involves separate step, which is called authorization. And in AIFC, this is done by its financial regulator, by AFSAM. So time required for obtaining license should be factored in the main overall timeline. So depending on the services to be provided at AIFC, it may take around 1-2 months maybe to obtain license, provided that all documents are collected and prepared in prompt way. Another group of issues, I call them intermediate issues. Those issues mostly relate to operational work of company. So obviously, the company would need to start the process of finding physical premises, physical office at AIFC. And this is something which can be also started as soon as possible once the decision is taken. Then engaging legal counsel is also relevant, especially for the stage when foreign company will need to obtain consents in its home jurisdiction, because as one of the documents which must be submitted to AIFC, it includes legal opinion issued by foreign legal counsel. So finding experienced law firm in its home jurisdiction is crucial to speed up the process. And here also important issues is obtaining actual consents and actual notification of clients, customers. Again, depends on the current business of the company. Another main and key aspect is tax and accounting nuance, because one of the documents which must be submitted as application package is that the company will need to submit the most recent accounts. And for non-licensed activities, I think it shouldn't be a problem. Company can submit its non-audited statements, but if company plans to conduct regulated services, such as financial services, then highly likely that the financial statements would need to be audited. And for those reasons, professional accounting team would be required. In terms of taxes, it's also important to note that foreign company will need to make all required tax filings in its home jurisdiction before it goes to AIFC, which means that company effectively will need to close all its outstanding debts, taxes, if any. And also one of the documents which foreign company will need to submit to AIFC includes declaration signed by directors, whereby directors will need to confirm that current assets of the company exceeds its current liabilities. So this is also something which professional tax team and accounting team would be would help for foreign company. So I would say engaging legal law firms, tax accounting team would be maybe relevant. But again, depends on the plans of the company, on its current size. So it can do that in-house, but if the size of the company is huge and if it exists for a long time, then retaining tax and accounting team would help to speed the process and to prepare all required documents in good way, in good shape. Bank accounts. I mentioned at the beginning that current assets and current rights of company, they just continue to exist. So bank accounts which are currently kept at international banks or it's in the banks of its own jurisdiction, they will still continue to be, they will continue to exist following transfer to AIFC. But from practical point of view and from operational point of view, it may be helpful to open bank account in AIFC or in one of the local banks in Kazakhstan for the purposes of working with local customers or local clients. So it's not mandatory, but it's something which can happen in practice, and something which we faced in practice when we worked for our client. On licensing point, also I want to emphasize that if the company is not subject to licensing requirements and if it conducts non-regulated services, then for such companies, moving its existing domicile to AIFC would be, I would say, straightforward. However, if the company plans to conduct licensing activities, which would be subject to regulation of AIFC, then there may be certain, there would be additional work stream involving obtaining license. And here, company would need to consider various requirements provided at AIFC, such as prudential requirements, specific requirements as to share capital of financial institutions, certain risk compliance policies that must be in place in order to be able to obtain license at AIFC. But here again, there is certain flexibility at AIFC level, because certain requirements, they can be fulfilled later when the company is moved, and AIFC AFSA can allow in certain cases, of course it's on case-by-case basis, but in certain instances, AFSA can allow certain requirements to be fulfilled later, let's say within 1 year following transferring the business to AIFC. So this another flexibility provided by AIFC. And the last point about post-transfer issues here, it's important to note that, again, depending on the company, in certain cases, transfer of business may trigger certain post-transfer disclosures or re-registrations of certain types of property. This may be relevant for real property or for shares, securities held by a foreign company, or certain IP rights also may require certain notification filings. So this is something which also must be considered post-transfer period. And here also employment-related issues also are relevant. Foreign company would need to consider requirements for employment matters in its home jurisdiction, whether it needs to it needs to notify its current employees about proposed transfer and to settle those employment-related issues. So it's another red flag for foreign company. And as concluding remarks, I would say that using our precedent, based on our experience working for CARE, I think we can definitely recommend this option as one of the ways to set up business in AIFC. And this also may serve as a good incentive for offshore registered jurisdictions to transfer their domicile to AIFC, which is more transparent jurisdiction as compared to certain offshore zones. So as I said at the beginning, we tested this option. It works. in practice, and it could be considered by foreign companies, by foreign investors, as one of the solutions to establish business at AIFC. That's all from my side, and I'll be happy to answer any of your questions if you have.
Yes, thank you for that, Kuanysh. Almas, have questions come in from the participants?
Yeah, sure. Thank you, Kuanysh, for your presentation. We have several questions. First is from Arman. He is asking, is creditor consent for transfer to another jurisdiction typically required in original domestic jurisdictions? And the second question is, what is approximately the range of costs associated with transfer for a transferring company?
Yeah, on cost, it's obviously depends on the company's current size. And if, as I said, if it is a company which has existed for a long time, and if it has certain assets and liabilities, then obviously it may require certain costs, because moving existing big company from one jurisdiction to another, yeah, may involve certain costs. But right now I can't assess the exact number, but everything I think will depend on the size of the company. If it's a non-regulated company with minimum assets, then the process would be straightforward, I would say, with not substantial costs.
Okay, thank you. And the first question was, is creditor consent for transfer to another jurisdiction typically required in original domestic jurisdictions?
Yeah, it depends on the provisions of current contracts. If it requires preliminary consent, then yes, foreign company will need to obtain such consents from its customers. This is especially relevant for banks. In practice, banks would usually include such provisions where a company would need to obtain such consent before launching the transfer process.
Okay, thank you. Next question is from Alia. She is legal intern. Is redomiciliation to AIFC recognized by international corporate and legal communities?
Yes, yes, it is. It is recognized, and it's something which is commonly used and applied in foreign Western jurisdictions. That's why it's another reason why transferring business to AIFC is very attractive, because it exists in foreign jurisdictions, it exists here. So yes, in this sense, it's same principles and same rules are applied. That's why it's so convenient to use this option.
Okay, thank you. The next question is, what is the legal effect and benefits for companies when moving from other jurisdiction to the AIFC? How the process differs from redomiciliation to other jurisdictions?
Yeah, as I mentioned before, AIFC provides sensitive and sensible privileges, tax exemptions, certain other exemptions, which are very attractive for investors from commercial point of view. And in this regard, plus, as I said, AIFC is considered as transparent jurisdiction. So those are two big factors for investors to move their businesses from tax haven jurisdictions to AIFC. And in this respect, it's something which they could take it into account. As for other options, if redomicile doesn't work, then there are other ways to set up company in AIFC, including establishing just new legal entity, or buying shares in existing company which is registered in AIFC. So depends on the plans and on the goals, on ultimate goals, and on structuring of the transaction, particular transaction. But alternative solution to redomicile would be just incorporation of a new company. And in terms of timing, I would say it's same, more or less would be same in terms of timing, in terms of documentation, process involved. I wouldn't say that transfer would take more time than opening a new company.
Okay, thank you, Kuanysh. And the last question is, if company was established in non-common law jurisdiction, where types of business entities are different, what type they can choose in AIFC? Is there any alternative methods of redomiciliation? I guess it's two different questions. First question is, if the company was established in non-common law jurisdiction, where types of business entities are different, what type of business they can choose in AIFC?
Well, if we're dealing with non-common law jurisdiction, then foreign company, first of all, would need to check if its jurisdiction allows transfer. Because if it doesn't allow, then this option is just impossible. And in that case, the most suitable option would be just opening new incorporation in AIFC. And also related point here, even if such jurisdiction permits transfer, I think certain analysis would need to be done in terms of corporate principles, terms, terminology applied in AIFC, because AIFC applies common law jurisdiction principles, and it may not work in non-common law jurisdiction. So this is something which I mentioned in my presentation as one of the preliminary issues. Foreign company would need to analyze its current legislation vis-a-vis AIFC legislation, whether it would be able to continue existing in AIFC. But
okay,
in theory, it is possible. If it allows, then yeah, of course it's possible.
And the last question is there any alternative methods to redomiciliation?
Yeah, as I already mentioned, I think the obvious alternative solution would be opening new company, new incorporation. There's also option to register presence as recognized company, which means that existing company can establish its presence in AIFC by acquiring so-called recognized status. It's also one of the ways establishing presence, but it has certain nuances and features. So yeah, again, depends on the goal and on the plan of applicant.
Okay, thank you.
Okay, Kuanysh, thank you so much. On behalf of the AIFC Academy of Law, we are really grateful for your time today. This was a highly relevant and practical overview of the logistics and processes, as well as the commercial issues surrounding the potential to transfer the domicile of your company from one jurisdiction to the AIFC. And then you also covered that there are different scenarios that would require a factual assessment of the situation that is brought to you as a lawyer to provide advisory services. One would be to change your domicile, as you've discussed. The other would be to achieve recognized status of your current company. And then the third could be form a brand new company. So we recognize it's a case-by-case analysis, and we really appreciate hearing your expert opinions and observations in this area. So for our participants, thanks to all of you. We had more than 50 people at one point, most of whom are still on the line. We really appreciate your time and attention today. Please feel free to contact Kuanysh directly if you or any of your clients have questions in this area or need any sort of support services. And really, when you step back and look at the big picture, the countries of Eurasia are emerging markets. This is a robust area of economic development. There will be a lot of commercial activity that will continue to grow in the region. And so if your clients are coming to you saying, look, we want to expand our business into the next big thing in the emerging market business segment, think about Central Asia and getting set up in the AIFC jurisdiction and make that your hub for the rest of your Eurasian business. So something to keep in mind as solicitors giving advisory, providing advisory services to your clients. So with that, thanks so much again to everybody, and have an absolutely terrific weekend. And we look forward to seeing you again in our future Academy of Law Learning and Development activities. Thank you.
Thank you.